All right. Well, welcome everybody. I'm attorney Justin Randall with Hooper Law Office. And today we're going to be talking about minimizing stress on your family through estate planning and through some practical things that you can do in connection to that estate planning as well, to really make sure that everything is as smooth as it can be for them, that they have as easy of a time with it as they can. You're never going to 100% eliminate stress from the entire situation, right? I mean, dealing with a loved one's affairs after they've passed away. I mean, the fact that they've passed away in general is also very stressful, right? So you're never going to completely eliminate that stress, but there are a lot of things you can do to minimize it substantially. So I want to start with a couple of things, but before I do, just a quick reminder that at the end of this, you will receive a feedback form, which allows you to let us know if you would like to set aside time with one of us here in our office to come in and talk. Our complimentary initial consultations are scheduled for about 2 hours. So again, those are complimentary. They don't cost you anything to come in and talk to us. But if anything we talk about today really brings up a desire to get this done for yourself or have your plan looked at again, this is a good opportunity for you. And then just to give you a heads up on our next upcoming topics, next week we're going to be talking a lot about planning around like up north properties, hunting land, family cabins, right? Whatever your up north property is. This is the time of year that a lot of people are starting to think about that with hunting season and all of that. And then the week after that, we're going to be talking about understanding Medicaid eligibility and some of the things that you have to be aware of if you were looking at that planning for yourself down the road, maybe concerned about nursing home expenses, or you think it might be coming up sooner rather than later. And then finally, our 2 weeks from now, our Green Bay public seminar will be happening at the Neville Public Museum instead of our weekly webinar. So, okay. And then, like I said, to get started out, there's a couple practical things that you can do in regards to your estate planning or in connection with your estate planning that really help the family, ease the stress on them, make things a lot simpler for them, or at the very least, make them more aware of where you have things and not have to go searching for everything. So first and foremost, practical and the legal side of things, if you don't have a plan in place, it's really important that you look at getting an estate plan in place. Because if you don't have a will or a trust or any plan at all, you're relying a lot on default statutes to potentially direct your assets when you've passed away, or you're relying on various beneficiary designations that you might have on your accounts that over the years you've set up. And if you're not sure of how those are currently set up, you don't really know how things are going to be distributed after you've passed away. So you want to first create that plan, because if you don't have a plan created, you're not doing any planning to minimize that stress for the family, right? The hardest estates to administer in terms of stress for everybody are the ones where nobody ever did any planning or didn't inform the family of the planning that they had, or didn't have things properly aligned with maybe the documents they were using. And things are kind of all over the place. So it's so much more difficult for someone to gather every ounce of information or deal with things in a timely manner if they don't have a plan at all, or if that plan is tenuous at best. So create that plan first and foremost. It's never too late to start until you pass away, right? That's when that plan can't be put into effect anymore. So create the plan first and foremost. But if you have a plan in place and you know that it's well established, that you have everything aligned with it in terms of beneficiary designations or ownership of the assets with your will or your trust, then talk with your loved ones about that plan. A lot of people don't like to talk to their family members about these things, I think, because sometimes it's a privacy concern, right? I don't want to tell these people what they're getting or what we have because I don't want them to know that yet. And while I understand that, it's at least very important for you to tell them what kind of plan is in place, who's going to be making decisions, what the overall design of that plan looks like. Because if they don't know these things, they're finding all of that out right at the worst possible time to figure everything out. When you've passed away, it's already stressful. Now they're, being bombarded with all of this information. So make sure you've talked to them first and foremost well in advance and kind of walk them through what's supposed to happen. Especially the people you have named in roles such as like trustee of your trust or as personal representative of your will. Even more so, and sometimes even more difficult to have this discussion, would be letting the family members know if you're not leaving something to somebody specifically. Maybe you're excluding one of your children, or you're specifically not including, a family member of a generation that you've included everyone else from that generation, right? Like maybe a grandchild or niece or nephew or whatever it is. It can be really helpful to talk to those people in advance, or at least inform the entire family that may have to get involved of, I don't want to leave something to this person, or if it's a child, I'm choosing not to leave something to you. That can be very difficult to have that conversation. But if nobody knows that's happening and everybody finds out after you've passed away, especially if that person who's being excluded finds out after you've passed away, it can really increase stress for the family members who are helping administer the estate. You would much rather, and not that you want this to be the case anyway, but you would much rather that person that you're excluding be upset with you for deciding that than be mad at your trustee or mad at their siblings, or potentially blame someone else for it who wasn't responsible for that decision. And there's certainly nothing wrong with excluding certain people. I mean, if that is what your wish is, that's what should be followed. But it's so much worse for someone to find that out at the worst possible time after someone's passed away, because everyone's already in a heightened emotional state where that sort of stress can really cause family rifts and really hurt the family relationship. And maybe you want to keep the family as close as possible, even though you're choosing not to leave something to somebody. So as hard of a discussion as it is to have, it's really important to have with the people that are going to be involved in the plan, and also the trustees or personal representatives of your will or your trust, and then also potentially even the people you are excluding. Now, I'm not saying you have to tell like every extended family member that, oh, by the way, I just didn't happen to include you because I'm leaving everything to my kids. That's totally different, right? But if you are specifically leaving one of your children out, I mean, that's the big one. That can be a really important discussion to have, as hard as it is, just because then they know now. They can certainly be upset with you about it, but if everyone's on the same page, it's much harder for them to cause a problem later on. So that's a practical step to take, not an easy one by any means. In terms of the documents that make up your plan, make sure they're organized and make sure somebody knows where to find them. So you don't want your will in one place, your powers of attorney in another, and then your trusts in an entirely separate location, right? They should all be together, and make sure they're accessible, because one of the biggest problems people accidentally create is they try to keep their will safe, and they'll put it in a safe deposit box or in a safe somewhere. And if nobody knows where that is, it's not that helpful to them, right? It's essentially worthless. Because if they don't know that there's a will out there or where to find it, they can't find it. There's the presumption that it was destroyed or is lost. So you need to make sure that it's accessible to people. Safe deposit boxes are always risky with that. Not because you can't eventually gain access to them, but because it just it lengthens the process of even just getting things started, because somebody has to get a court order potentially to open that safe deposit box to find the will. And they may not even know if the will is actually in there, right? That they're sort of hoping it is at that point. So make sure things are accessible and organized for people, and not just the estate planning documents themselves, but also like things like statements, right? You want to make sure people know where you have your assets, what companies you work with. If you have passwords to certain things that people are going to need to have access to, accounts or social media or whatever, make sure you have a list of those, or potentially a password management app, so that somebody can more easily gain access to those. And I don't mean just anybody, but somebody being the person in charge of those financial decisions, or paying the bills after you've passed away. They in particular really need to know where things are, how to gain access to them, or who to talk to gain access to them. Otherwise, it can really make that process much more stressful and take a lot longer. One of the biggest sort of problems that people accidentally create for themselves is when they don't inform either their surviving spouse, maybe one spouse is more involved with the finances than the other, or their children of where they have things and they've never talked to them about it. And so they don't even know where to look. And that can really make that start of the process take so much longer, because you really need to have a good picture of what the estate looks like before you can start really administering things in full. So you don't want to have people searching for accounts, taking time to go talk to all the banks in the area to see where you might have had a bank account, right? Or waiting for statements in the mail, making sure that it's easily accessible and kind of compiled in a list or in one place for people to know what currently exists is really helpful for them. One way to get around this too is if you work with a lot of professionals. You work with financial advisors, maybe CPAs, attorneys that you work with on your estate planning documents or your financial decisions. Introduce the family members that will be involved in the plan to these people, because maybe they don't need to have statements accessible to them if they know they can go talk to your financial advisor who has all of those statements accessible and will help guide them at the time. And this actually works both during your lifetime and is helpful after you've passed as well, not just because you're introducing them and they know where things are, but because they can get advice from these people after you've passed away. Don't think that the person you're naming in these roles has to do it by themselves, right? They have the ability as a personal representative or as a trustee of a trust to hire professionals to help them at that time, or to work with your previous advisors to help them at that time. You don't have to do it alone, and you certainly wouldn't want them to go at it alone, because there's a lot of things that if you don't know what you're doing with it, one, increases stress, of course, but it also, there's the fear that they're doing something incorrectly, or that they're, not following all the steps properly and then end up creating more problems down the road. So having that guidance is essential, and making sure that they know which professionals you've worked with so that they can have easier access to the information. Or like on the attorney side of things, for example, the attorney can help guide them through the process of probate or of a trust administration, right? That can make that process so much simpler for them. There's still always going to be certain things that they're going to have to do work-wise that, I as the attorney can't help them with, or the financial advisor maybe can advise them on, but can't do for them. Decisions they're going to have to make, and they're the ones who have to make those decisions. But getting that guidance can make that process so much easier than them trying to make that decision based off of maybe something they're Googling or just hoping they're making the right call without any outside advice. So working with professionals, both for yourself and for your family, can make that a lot easier, whether you work with advisors now or you're concerned about, for a surviving spouse or for your kids, making that process a lot easier. You might want to consider looking at working with advisors so that process is a lot easier. So yeah, definitely don't go about it alone. I hear a lot of people talk about the trustees or the personal representatives named and say, I don't know that, they're going to want to do all that by themselves, and they don't have to, right? They can certainly try if they want to, but it's not really advised. It's always a good idea to talk with a professional. There are plenty of situations where, somebody wasn't trying to do something incorrectly, but because they just aren't, informed on all of the rules of like probate, for example, maybe they miss a step, or that step they missed ends up causing a problem down the road. And then the last really important thing, and the biggest thing in regards to making sure that you're minimizing stress for your family members, is making sure not only that you have that plan in place, but that the assets that you own, your home, your bank accounts, IRAs, retirement accounts, investments, whatever it is, making sure that those assets are actually going to utilize the plan that you've created. A lot of people are under the assumption incorrectly that, well, I have a will, so that means that's what's going to happen, right? Regardless of anything else, this is how things go. Or I have a trust, and that's how things get divided. So it doesn't matter, what else happens, that's the final say. That's what has to happen after I pass away. And that's not true if the assets are not properly coordinated with those documents. So one of the things you'll receive at the end of this is a list of top estate planning myths. One of the biggest myths that we run into is that wills avoid probate, or that wills are kind of omnipotent and all controlling, right? So wills only direct probate assets. They do not direct assets that are transferring outside of the probate estate. They don't just control or override all of the beneficiary designations that you have, or the joint ownerships on assets that you might have, like joint ownership on a bank account, for example. They only direct things in accordance with the will if those assets are subject to probate. So most people with wills end up, if they haven't been advised on this, end up creating a lot of headaches for the people, the personal representative administering the estate, because they have certain things payable on death, maybe not following the percentages of the will, or to one person as opposed to all of the beneficiaries. Or maybe they do have everything following the will, but nothing actually ends up going through the probate estate. And this can create a lot of problems, because wills are tools to use that have protections for people who maybe have a disability. They can make sure that they're not, if somebody has a substance abuse problem, they're not going to just be in control of these assets, right? But really, in terms of just minimizing stress, you really want to make sure that the person in charge of the estate, the personal representative, also called an executor, it's the same thing, that they have access to funds before those funds go out to all the beneficiaries, so that they can more easily pay expenses. This is probably the biggest headache we run into with probate, when somebody doesn't have a lot of assets actually in the probate estate. If they're using a will as their primary estate planning document, is they will either have everything equally divided amongst their beneficiaries like they wanted, or how in whatever proportion they wanted, and then the personal representative is stuck managing the estate, but with very little or no cash assets to pay expenses out of. And sometimes that personal representative is also one of the beneficiaries. So what they will probably end up doing is using what they've received to help cover those expenses and pay the bills and do all of those, cover those expenses during the administration. The problem with that is then, did they actually receive the proportion of the estate, the percentage of the estate that you actually wanted them to? If everything was divided equally, but only one person helped cover the expenses, they sure didn't get their fair share at the end, because they covered more of the cost than everyone else did. And there's no obligation that those other people have to cover those expenses or to contribute to them. So it can create a lot of tension amongst the beneficiaries of, you didn't cover your fair share, or I had to use all of my share to cover these expenses because I was the one put in charge. Well, if you're using a will and you have a personal representative you're putting in charge, if you have a bank account or some sort of liquid cash fund left to your estate rather than directly to all of the beneficiaries, well, then that person is going to, in that role, have access to those funds. And then only after the expenses are paid will things be divided up equally or in proportion to the percentages you've named. So it guarantees that everybody shares in those expenses equally, and that you don't have any sort of infighting over, well, who's covering what expense, or, I asked you to help me and you didn't, things like that. And then, of course, the alternative to that is, a lot of people will say, well, I'm just going to name that person as a beneficiary on the account, the personal representative, so that they can pay expenses and they don't have to worry about, asking other people for their share of the expenses. And while that sounds like a solution to that problem, it can create other issues as well. When you leave an asset to somebody as a beneficiary, that becomes theirs. They don't have to split it. If there's money left over, they certainly don't have to share it the way you would want them to, or they legally may not be able to. So there's times where somebody might be in a bankruptcy, or getting sued for some reason, or looking at nursing home care, and they're worried about Medicaid. Well, those people can't just gift money away, even if they wanted to follow your wishes. So it's really important to not force them into that decision of, well, do I follow mom and dad's wishes, or do I cause myself a problem because I'm, gifting when I shouldn't be? And when you have something through your probate estate with your will, if you leave that account to your estate, that personal representative, one, like I said, can use it to pay expenses, but then it's not up to them whether they choose to split it or not. They have to split it the way you would want them to if there's funds left over from that account. So it really takes that a decision away from them and make sure that the end result that you would want happens over those assets. And even more importantly, that if they have those personal liabilities coming up that I mentioned, bankruptcy, lawsuit, long-term care, or whatever it is, where they can't gift money out, those liabilities don't attach to the estate funds because they don't own them yet. So it's really important to make sure that if you want a certain result to happen and you're using a will for that, your estate plan, that you coordinate your assets with the attorney you're working with your financial advisor, to make sure that there are funds in the estate, not directly to the beneficiaries. Now, that's not going to be the same by all accounts. Certain things like retirement accounts might be different, but you want to make sure that the vast majority of what you have is subject to the document you're using. And if that's a will, that involves using probate. On the other side of things, if somebody has a trust that they're using to direct assets, in order to really make that less stressful, you have to make sure when you're setting that trust up that you work with someone to either title things properly in the name of that trust, or use the payable or transfer on death designations to direct it to that trust after you've passed away. Because just like a will, a trust only controls certain things. Wills only direct probate assets. Well, trusts only direct the assets that they control at the time of your death or after you've passed away. So whether they own it now and they continue to own it after your death, or they will, the trust will own those assets after your death because of a beneficiary designation, whichever of those is how you get those assets to the trust, that's really, really important in order to make sure that the directions in the trust apply to all of your assets. Because that is something we see a lot of as well, just like with wills that don't have assets go through probate. A lot of trusts that after someone's passed away that, maybe they've had for 20, 25 years, and it's been forever since it was set up or looked at, they might have some assets in the trust, or a lot of them are just left directly to the kids again, because of advice they've received from somebody at the bank or they've read online, for example. So if you have a trust, you really want to make sure that you're using it by leaving things to that trust directly through a beneficiary designation, or making sure that you have things titled in the name of that trust. And that is, I'm oversimplifying it just because if I talked about every kind of trust and how that would differ trust by trust, we'd be here not just all day, but probably all week or longer. So know that can vary depending on the type of trust you have, the reason you're setting up that trust. But if we're talking about a revocable living trust, that would be sort of probably the most common kind of trust that somebody would have. That's where you really want to make sure things are owned by that trust or designated to that trust as a beneficiary. Because just like the will, the trustee has to make sure that those funds are used primarily to cover expenses first. And then whatever the trust says to do, whether it's split things equally or by certain percentages or certain dollar amounts, they have to make sure that that happens with the remaining funds. So it's really important that if you have a trust, you have those things directed properly. And that's true, again, like I said, of wills, making sure things are directed properly with the probate estate if you're using a will instead of a trust. And they're not going to be the same for everybody. It's going to depend a lot on what kind of assets somebody has. If everything they have is in retirement accounts, that might look different than if they have a lot of just traditional investment mutual funds, right? So what's really important, not that you leave that up to the kids to figure out, or that you try to figure that out yourself, but that you work with somebody who knows how to allocate those assets properly, and that you get advice from the attorney on it as well as from the financial advisor, and so they can coordinate and make sure that things are set up in the most tax efficient way as well, but also in the easiest way to administer after someone's passed. Asset alignment is what we would refer to that as. Don't work under the assumption that you have a will or you have a trust and therefore you're covered, because they might be the best will or best trust ever written, but if they don't control the assets that you have, they're essentially very fancy pieces of paper that are worthless to you. So make sure that you direct those things properly. And then, like I said, so that's more the legal side of things, but the practical side is honestly equally as important, because again, even with the most well-crafted will or trust, everything's coordinated properly. If there's surprises or people don't know where to look or who to talk to about those documents, it can still create a lot of initial stress or problems as somebody scrambles to try to figure out what to do. So introduce those people, the trustees or the personal reps, introduce them to the people you work with, at least give them the business card of those people so they know who to reach out to. I mean, one of the first things I tell somebody is, hey, if you want your kids to talk to me and you want me to explain things to them, I'm more than happy to do that. And tell them to reach out if you want me to talk to them about that, because I'm more than happy to help make sure they understand, or that they know who to talk to, or that I'm not just the scary attorney on the other side of the aisle. Right. With that, I will let you guys go and enjoy the rest of your day. But again, just a quick reminder that you will receive a feedback form that lets you let us know if you'd like to reach out or us to reach out to you to set aside time to come in for an initial consultation. Again, those are complimentary. We do schedule them for about 2 hours to give us plenty of time to talk through things, and hopefully give you a good recommendation by the end of those, that 2-hour time frame. And then keep an eye out as well for that top myths of estate planning. I covered some of them today, but I didn't focus on more than a couple just for time's sake. But it can be a really helpful tool just to sort of open your eyes to, oh my gosh, that's not how that actually works. So I need to maybe talk to somebody about this. And then finally, just one last thing. Again, next week, if you have up north property or loved ones that have up north property, and again, it doesn't have to physically be up north, but your hunting land, cabins, things like that, that you are looking to plan for the next generation, or to make things a lot smoother in terms of transition to whether it's a sale or a transition to the next generation. We're going to be talking about planning for that type of property next week at the same time as today. And then the week after that, we'll be talking about understanding Medicaid eligibility. And then the week following, so 2 weeks from now, will be our Green Bay Public Seminar, where we'll talk about wills, trusts, powers of attorney, all of our general sort of overview topics, as well as Medicaid topics as well. So with that, I will let you guys go and enjoy the rest of your day. Thanks for joining me, and I hope